Okay, good morning, everyone. Welcome to the last of my video series on the FARBAR and NABOR contracts and what you need to know. Today, we're talking about default. Your customer defaulted. Now what? We're going to compare the provisions of the NABOR and FARBAR contracts. And as you know, if you've been on this series, my name is Sam Saad, and I am an attorney here in Southwest Florida. Because I'm an attorney, we start with a disclaimer that I'm providing you advice that's not legal advice, and we do not have an attorney-client relationship. If you do need an attorney, you should contact me separately. A little bit about me. I've been an attorney for over 20 years, and I specialize in real estate law. I think most important for this presentation, I am the scribe and past chair of the NABOR Legal Resources Committee, which drafts the NABOR contract, and I'm a member of the Florida Bar, Florida Realtors Joint Drafting Committee that drafts the FARBAR contract. And our firm's been around since 2007, and we focus on real estate and business law and helping property owners, realtors, small business owners, entrepreneurs, buyers, and sellers with all of their real estate and business needs, including estate planning and probate. And I've got offices throughout Southwest Florida. I have a title company, Paradise Coast Title and Escrow, for all your closing needs. Just give me a call at the number on the screen, 239-784-5556. I'm also really excited to get Qualia Connect started on October 1st of this year. So you will have much more secure transactions in my office here in a couple of weeks. And I encourage you to give me a call and we'll talk about that. Again, today we're talking about the default provisions of the NABOR and FARBAR contracts. So we're going to dive right in. I want to give you an overview, like I usually do, of the provisions that we're talking about today. Today we're talking about Standard O and Standard P in the NABOR contract, and we're talking about paragraph 16 of the FARBAR contract. And this is what the FARBAR contract looks like. You can see from both of these, there are short provisions. There's not a lot of meat on the bone here, so to speak, but there is a lot of substance because it's very, very important if the buyer or seller default, who pays attorney's fees, what constitutes a default, where does the deposit go, and what are the remedies. So again, here's the FARBAR provision, buyer default, seller default. Let's break these down. So in NABOR, if the buyer defaults, if the buyer does not perform buyer's obligations hereunder, that's the contract, except excused by seller's default, seller may terminate this contract and all deposits made shall be paid to the seller as liquidated damages, which shall be seller's exclusive remedy. So that's what NABOR says for the buyer, for the seller, I mean, if the buyer defaults. What does this mean? Deposits made shall be paid to seller as liquidated damages, which shall be seller's exclusive remedy. Well, under the NABOR contract, if the buyer defaults, the seller gets the deposits held in escrow, and that's it. They don't get a specific performance. If they spent money, they don't get that back because hopefully they're spending it to improve the property, but they do get the deposits. Now, if you go to litigation under either contract, and I'll talk more in detail about attorney's fees at the end, but if you go into litigation, you would get your attorney's fees paid, but you would not get a whole string of damages. You would get the deposits made. So it's very important in the NABOR contract to get that deposit in as quickly as possible. I see people putting 3 days after the effective date for the deposit to be made. And that's fine. I agree with that. But just remember that for 3 days, you have a contract. You are in contract. The buyer and the seller have obligations, but the buyer has no loss potential because they have not made the deposit yet. And the seller has no remedy because there's no deposit made yet. Once that deposit's made, then the seller can say, well, you defaulted if they did something else wrong, and the deposit should come to me. FARBAR um, takes a little different approach. If the buyer defaults, including on the payment of the deposit, then the seller can keep the deposit as liquidated damages, or they can sue the buyer for specific performance or regular damages. But it's an or, so they can either take the deposit or go to litigation, which of course it's usually better to get a bigger deposit. Excuse me, better to get a bigger deposit than go to litigation, and then you just keep the deposit as liquidated damages. FARBAR is a little bit more comprehensive, and I'm going to talk about that a little bit more in a few minutes. NABOR is pretty simple. Default, deposit goes to the seller. So what happens if the seller defaults? It's a little more complicated. Under NABOR, if the seller does not perform seller's obligations hereunder, except as excused by buyer's default, buyer may enforce this contract by a suit for specific performance damages or may terminate this contract. And if they do terminate, the deposit goes back to the buyer. So the buyer, if the seller defaults, which is very hard for the seller to default because all they have to do is show up at closing with marketable title. But say they don't sign, they don't want to sign, they're not happy with the deal, they're upset with the buyer for whatever reason, they don't want to come to closing. The buyer can sue for specific performance. That's where they force the seller to sell in the courts. And that's a great lawsuit for me because I take the attorney's fees that I was going to get paid from the buyer out of the seller's sale proceeds. So there's plenty of money in the specific performance action on the buyer side for the attorneys to get paid. So you never want to go down that route unless you're really sure you're going to win as the seller, which would mean you'd have to prove that the buyer somehow defaulted first. And it's very similar under FARBAR. If for any reason other than failure of seller to make seller's title marketable after reasonable diligent effort, seller fails, neglects, or refuses to perform seller's obligations under this contract, then the buyer can either take the deposits and uh, sue for damages, or they can seek specific performance under paragraph 16, which I'm going to show you in a second. But let's notice the difference. If the buyer defaults, seller gets the deposits, or under FARBAR they can sue for in specific performance, but that's a very difficult lawsuit. If the seller defaults, then all the gloves come off, and the buyer can sue for damages and specific performance. So what does FARBAR paragraph 16 say? This is a very interesting dispute resolution. Um, the buyer and the seller under FARBAR have to demand the deposit. Then they have 10 days to resolve their dispute or go to mediation under Florida statutes. If they don't get resolved in mediation, then they can sue each other. But and I didn't put the provision paragraph 17 in my slide presentation of the FARBAR contract for one simple reason. There's a really interesting court case that just came out a few months ago called the Pisantes case. And in Pisantes, the court said that they didn't get their attorney's fees paid. The seller didn't get their attorney's fees paid because they didn't follow the proper rigmarole in the contract, for which states here, buyer and seller shall attempt to settle disputes in an amicable manner through mediation first. If they don't go to mediation, then they can sue each other for the deposit, for damages, for specific performance. But the language used in paragraph 17 was not clear, and the court did not award attorney's fees. So, as I said in the beginning, I'm on the FARBAR Joint Drafting Committee. We just completed our review and approval of a complete rewrite of paragraph 16 and 17 of the FARBAR contract. So in a few weeks, maybe by December 1st, there's a few more levels of approval for FARBAR they've got to go through. Maybe by December 1st, you will have a whole new dispute resolution provision in the FARBAR contract. So I'm kind of avoiding some of the details today. Like I said, I'm not even showing you paragraph 17 because it's being completely rewritten, and it was basically determined to be invalid in the Pisantes case. So again, today is a very short presentation because the disputes resolution is fairly simple. The deposit is there for the seller to collect. Under NABOR, it's the exclusive remedy. Under FARBAR, the seller can seek damages or specific performance, but that's a very hard lawsuit to force the buyer, especially if they've got financing, to force them to close. If the seller defaults, then the buyer can sue all day and get the property in most cases from the seller. And with that, questions?
Hi, Sam.
Jessica.
I have a couple questions. So,
Yeah.
what if the seller did not provide all of the HOA documents? Would that be a default?
It could be considered a default, but it has its own remedy in the statute, and that the buyer can void the contract, get their deposit back, and walk away. So you would not have the big full blown lawsuit. I mean, I suppose if a buyer really wanted the property, the fact that they didn't get the documents, they could would sue for the documents. But the fact they didn't get the documents, if you show up at the closing, they can still close. So it's not a default per se to not provide the documents, just the buyer just has an out.
Okay. And then I have a question. We had a closing with the Saad team, and you were the attorney, where the buyer, we scheduled the walkthrough, and in the walkthrough, we saw that the condo had flooded and we weren't able to close, so they had to do the remediation. And when we went back to the second walkthrough, the buyers were still not happy with the condition. But from my understanding, per the contract, they still had to close. So wouldn't,
So you talk about this was a NABOR. I don't remember this specific case, but this was a NABOR contract.
yes.
So yeah, the buyers would be obligated if they did their walkthrough, um, even after the first walkthrough, if there had been flooding, as long as the buyer could get insurance, they would have to close, and there would be an escrow because under NABOR, the walkthrough, you've got four things that you inspect for. You make sure the property is in the condition it's supposed to be in, that the stuff is supposed to be there is there, the stuff that's not supposed to be there has been removed, and any remedial action has been taken. And so if the property was not in the condition of the effective date with any repairs made at the closing when they did their walkthrough, the buyer should have closed and we should have done a 200% escrow. So I don't remember this particular
Mhm.
file. I can go back and look at it. We talk about it offline, but the
Yeah, it
normal
was
course of things, the buyer should have closed.
they the condition, in the first walkthrough, the property definitely was not in the original condition because even the seller had just found out the day before that a line um had broke and it was completely flooded. So all the flooring, all the laminate floor throughout the whole unit
Right,
had to be gutted. The kitchen had to be gutted. It was cabinet work. It was a lot of work. So that's why I think it was such a large job. Maybe that's why there wasn't 200% held in escrow because we had no idea how
right. And
big of a
you get,
damage.
I mean, you get those deals, and the NABOR and the FARBAR contract really are not perfect in this regard. I mean, there is implied good faith and fair dealing and diligent effort in these contracts just from the common law,
Hmm.
but you can have a situation where, like, and I do remember this now. This is the one with where the pipe broke.
Hmm.
Um, I do. you run into those situations where it's just so catastrophic that you just need to pause the contract, and there are other options. And I remember now how we dealt with this
We had
case.
to get quotes on
Yeah,
cabinet,
get
on
the quotes,
flooring,
and it just wasn't going to get done in the
baseboard.
time period before closing.
It
So
was no way. It was the day
yeah,
of closing when we found that. And so they closed after the second walkthrough. I mean, we
right,
then went in and there was like no floor. It was just definitely not move in, and it was a difficult situation for the buyers because they had moved from Georgia the day of
right.
walkthrough
But
and they
then again,
had
none of that really matters in the contract. You know, I mean, I get this, the equities, and you can argue that, but I remember that was a
yeah,
tough
and she
contract
was
to close.
worried. She's like, "How will I know if there's mold in a month, you know, in certain places?"
Right.
It was just hard
Yep.
to know. And then
Yeah,
we actually
remedial action can be a big deal under NABOR, but
yeah.
they no, I remember nobody defaulted on that. We did, we all got along on that one. So
Yeah, everybody worked
other
it out,
questions?
thankfully. Mhm.
Just seems like a good place for a lawyer at that time.
Yes.
Yes.
Other questions people have? Nobody's got anything. You understand defaults? Typically, I will say this about defaults as we sign off here. Remember that the default provision in the contract is that in the NABOR contract in particular, but really in both contracts, is the deposit goes back to the buyer. So if there's ever a question, there's a line in the NABOR standards that just says the deposit should go back to the buyer unless the seller is in breach. So that's kind of the way makes it for a lot of issues. That's kind of how it just ends up is, well, you know, the seller breached, so the deposit goes to the buyer, and then they kind of just wrap it up. But with that, I'm going to say thank you everyone for participating today. Thank you for the video series. And if you have any questions, call, text, or email anytime. Everything is going to be posted on my YouTube channel. You can tune in and rewatch whenever you want. Thank you very much.
Thank you.
Thank you.